And now there is a period of time provided to the traders, to the companies, to prepare themselves for complying with its requirements. First of all, we need to speak a little bit about the scope of the law, because it's a little bit strange, or could be somehow confusing, because the law actually applies to two major areas. The first area involve rules on supply of digital content and digital services to consumers. This includes requirements for conformity of the digital content and digital services, remedies for the consumers in case of non-conformity of the supplied digital content or digital services, or in case of failure to supply, rules on the modification of the supplied digital content and digital services. And then there is a second part, major area of rules that are included in the scope of the law that concern the sale of goods to consumers. And these rules, in comparison to the first group of rules, concern not only digital, does not concern the digital content or digital services, but the sale of goods in a traditional manner. Actually, any kind of goods, any kind of sale of goods to consumers fall within the scope of the law. So these are general consumer protection rules. And after the entry into force of the law, these rules that were existing on conformity of goods and remedies in case of lack of conformity of the goods, and consumer claims will be invalidated in the general consumer protection law, and will start, and the new rules that are in this new law will start to apply, but they are quite similar, and I will explain a little bit about it. This technique is, from a legal perspective, is maybe not the best, but that these are the rules, and I wanted to note this important aspect. So one part of the law concerns traders that provide digital services and digital content, and another part of the law concerns generally every trader that deals with consumers. And who are the consumers? Consumers are natural persons that are acting outside of their professional business activity. So when we deal with such kind of counterparties, we will need to comply with this law. The law, as said, already transposed two European directives that are part of one and the same package, but concerns those two different topics that I already explained. And it will enter into force on 1st of January 2022. So we have something like a little bit more than half a year to prepare and to become compliant with these rules. Certain rules of the law will apply only to contracts for supply of digital content or digital services concluded after 1st of January, but not all. So for contracts that have been concluded before 1st of January 2022, some of the rules will apply and some of the rules will be excluded from application. The key information that we need to share about this law is that, as I already said, it revokes certain rules of the law for consumer protection. The rights stipulated in this law cannot be restricted. These are consumer protection laws, rights, and they cannot be restricted by means of contract. So it is not, most of the rules that I will discuss today cannot be overruled with contractual clauses, and we cannot avoid their application in this way. Any clause, arrangement by which consumers' rights stipulated in this law are excluded or limited in advance is invalid. This means that if we allow ourselves to have such kind of clauses in our general terms, from legal point of view, they will be null and invalid and will not apply. The law concerns all traders that enter into contracts for sale of goods with consumers, as already said, And regardless of whether the sale is performed online or in presence. And there are some exceptions from the application of the law with regard to digital services and digital content, where such services as healthcare services, financial services, telecommunication services like the internet connection service and others are excluded from the scope of the law. But when we say healthcare services, we mean the pure healthcare services. For example, some healthcare mobile applications could fall within the scope of the law. So this is an aspect that we need to analyze and look from the perspective of our own business and to check whether we really fall within the exceptions of this law. The main topic of this law are the digital content and the digital services. So first we need to know what is meant by digital content and digital service under the law. First, I can say that it's a little bit difficult to make distinction between digital content and digital service, but I'll say that this is not really the main issue, because the rules are pretty much the same for both. So this distinction is not that crucial. And I would expect that now and in future even more, there will be a lot of connection between digital content and digital service, and we may face some difficulties to distinguish this, but I don't think that this will make a big difference from the perspective of complying and applying this law. So digital content under the new law is data which are produced and supplied in digital form. Now, to make this more clear, I will give examples like, for example, one computer program, application, mobile application, video files, audio files, music files, digital games, electronic books, other electronic publications, and so on. This in general means digital content. While digital service is a service that allows the consumer to create, process, store, or access data in a digital form, or a service that allows the sharing of or any other interaction with data in digital form uploaded or created by the consumer or other users of that service. So not every kind of service that we use digitally or in online environment is a digital service within the meaning of this law. This is very important. So these are services that are addressed, that are targeted to consumers, and one part of them are such that allow creating, storing, processing, accessing data. So these are, for example, software as a service type of services like cloud services. Some and other services are related to the ability of sharing content and interacting with other user-generated content. For example, some platforms for video and audio sharing, for file hosting, photo hosting, some social networks and medias, games offered in the cloud computing environment, and so on. So the scope is quite large, and I would expect that it will become larger and larger with the time. The law is technically neutral. This is very important to make sure that we are mentioning, because it doesn't matter the very technology that we are using. It's about the interaction with the consumers that makes our business to fall within the scope of this law. The main aspect of the law is regarding the supply of digital content or digital services. In general, what the law is trying to do is to make sure that when the consumers are using such kind of services or such kind of content, their rights are properly protected. The law contains a lot of rules. Today we will not be able to mention and list all of those rules, but I can say that in general these are already known to the business in these sectors, because they are coming from general ethics and good practices and proper and correct interaction with consumers in this area. So the law is just introducing some minimal requirements and guarantees for the rights of the consumers when they're using such kind of content or services. The law will apply to any contract under which the trader provides or undertakes to provide digital content or digital service to a consumer, and the consumer pays or undertakes to pay a certain price. So this is the general rule. But what is more interesting, and I would say this may be quite challenging rule to interpret and apply in practice, and we'll wait to see the actual regulators and court practice on this topic, is the fact that the law introduced another concept, that not only contracts that are against remuneration for the trader fall within the scope of the law, but also contracts under which the consumer does not pay anything, does not pay with money, but provides personal data to the trader. And this personal data is used by the trader for something else than the sole purpose of just providing the service. And I think that this should be interpreted in a strict way, so meaning just the data that is really necessary technically to provide the service, or to comply with some applicable regulatory requirements. So for other if the trader uses the personal data for other purposes, then then the rules of this law will apply. So this is something like the concept of paying the price for the service with our personal data. I think that this concept has been mentioned many times, and I would say that this is very tricky topic. Why? Because from one side, the personal data and the right to protection of personal data is a personal right. It's a human right, fundamental human right for all European citizens, and therefore the personal data are not just goods. This is not something to use for payment. Yet the law and the European legislator considered the fact that nowadays the personal data is already an asset, and they wanted to make sure that even in cases when the consumers do not pay the price for a certain service, they are not put in danger. Their rights are not restricted in an appropriate manner. So that's why such kind of contracts fall within the scope of the law. What will be the challenge? The challenge will be the fact that it is very difficult to make distinction between what personal data are really necessary for the provision of the service and what personal data are actually used by the trader for other purposes. I think that this will be the provision of the law is not really precise, and we will have challenges in this aspect, but we will need really carefully to analyze our business. For example, if we use the consumer's data, for example, for some statistical purposes that are, for example, we are selling some statistical reports after that to other businesses based on the user's data, or of course social media, all kinds of social media like that we are using in our day-to-day life fall within this scope. Actually, this rule is mainly addressed to this type of businesses, social media services, but I believe that because it's very general, it will encompass many other businesses, and needs every time we will need to analyze carefully the free of charge services to check whether we fall within this law or not. Then the law also regulates how the content, the service are supposed to be supplied. And in general, this is something very, very logical. The service or the content should be supplied without undue delay after the conclusion of the contract, unless we have other arrangement, other agreement with the consumer. And here I would say, and I will make a connection with the consumer protection legislation, where we have the right to withdraw of the consumer when concluding these distant contracts, online contracts. This is very important because sometimes it is because for providing, for supplying digital content and digital services, in most cases, the provision of such content and service within the 14 days when the right to withdraw applies cannot start without the explicit consent of the user, of the consumer, for the start of the provision, for the start of the supplying of this, for the delivery of the service and or the content. So we need to make sure here whether we are having consent from the consumer to start the provision of the service of the content, or whether we need to wait these 14 days. The content is supposed to be properly supplied when it is accessible in a suitable manner for access or downloading, or it's provided on a tangible or a virtual instrument selected by the user for that purpose. So all the different instruments that we are using, if the user can access and or download the content, then we consider that this content is supplied properly. For the digital service, it's supposed to be considered supplied when it becomes available for the user or to a material or a virtual instrument selected by the user. It's meant like, for example, when this digital service is available on my, for example, on my phone. The main part, one of the major parts of the rules in the new law are about conformity of digital content and digital services. In several slides, I'm explaining the requirements regarding the conformity of digital content and digital services, but I'd like to mention and clarify a few things outside of the slides beforehand. First, those requirements on conformity are pretty general. And second, these requirements on conformity of digital content or digital services are quite similar, of course, taking into account the specific nature of the digital content and digital service that they are provided in digital form. But besides that, those requirements for conformity of digital content and digital services are pretty similar to the requirements for conformity of goods that are stipulated in the other parts of the law. So I will not repeat this. Most of these requirements for conformity are pretty much similar for the goods. So of course, at first, the supplied digital content or digital service should correspond to the description, the quantity and quality, and should have the functionalities, compatibility, interoperability, and other characteristics as provided in the contract. So they should correspond to what was agreed between the consumer and the trader. Then they need to be fit for the specific purpose sought by the consumer. However, here we have some exceptions because it is important how this content or service has been presented to the consumer, whether it is reasonable to be expected by the consumer to expect that this content or digital service will be fit for his or her purpose, and so on. Next, all those content or services should be provided with all accessories, instructions, including regarding installation or rendering of assistance to the customers provided in the contract. And they need to be updated in accordance with the provisions of the contract, because as you can imagine, digital content and digital services are always related to some kind of updates. For example, software updates or update and supplementation of the content and so on. Then the content of the services should be also fit to the purposes for which the digital content or digital services of the same type are normally used on the market. They should be provided together with this is some together with the instructions that the user can reasonably expect to receive. How to use this content or service, how to install, how to integrate to his environment, and so on. They also should correspond to the trial version or the preliminary review of the digital content or the digital service. This is very, very important, because if we present a trial version that is significantly different and create different expectations for the consumer, this will be considered as misleading the consumer. So we will need to make sure that our trial versions, preliminary reviews, description of the content of the service are enough, create enough good idea for the consumer and proper expectations what he or she will receive when purchasing the content or the service from us. And then we have another very, very interesting and maybe the second newest aspect in this law, after the option to pay with your somehow to pay with your personal data, and this is one requirement related to the conformity of the digital services and digital content. So the digital content and digital services should possess the qualities and should perform have the performance which are common for the digital content or digital services of the same type, and which the user can reasonably expect. Here there is no something really unusual that we cannot expect to be put as a rule in the law. What is very important, however, is the second part of this rule, because it introduces requirements that the content or the service should also comply and be in conformity with all the public statements made by the trader or other persons at the previous stage in the chain of transactions, or made on behalf of the trader or on behalf of those persons contained. So what is meant by this rule? This means that it's not only important what is written in your general terms in the contract when we sell the content or the digital service. It's also important how we have advertised this content or service, how we have presented to the public, to the audience, our content or service, and even more, not only the trader, how the trader did presented this content or service, but also how this content or service have been presented by other participants in the chain of transactions, so like a producer, developer, and so on, because nowadays of course the business is pretty complicated and we have many co-branded services or content. We have different stages of distribution. So this is very interesting rule that means that in practice, as a traders, we will need to be very careful now, not only how we advertise and present our services or our content, but also how our partners that are involved either in the production or distribution of the content or the service are presenting this content or service, because we may be held liable if there are some misrepresentations in these public statements that are made. And this also is very interesting. This is a novelty as a rule. Till now, most cases when certain service or content have been advertised and presented to the public in not in incorrect manner or misleading manner to the consumers, to the market, were mostly subject to competition protection rules and competition protection regulators. But now we have also additional aspect, and this is the consumer protection. If our content or service does not comply with and is in conformity with such kind of public statements, then of course they will have the rights to those remedies that are provided by the law, and that we'll discuss a little bit later. Unless we are able to either prove that we did not know or could not reasonably expected to have known of the relevant public statements. This of course means that these are statements from third parties, from our own statements we are obviously aware of, or at the time of the conclusion of the contract already such public statements have been corrected in the same way as in which it was made initially, or in another similar and proper way. This means that we already made some efforts and make sure that we are informed, we have informed our consumers that the made public statement was not correct initially. Or in cases where actually the consumer decision to acquire the digital content or digital service could not have been influenced by the public statement, which is the most important part. The most important part is that the consumer, such kind of public statements are problematic because they may mislead the consumer and in this way change their decisions whether to purchase this content or services or not. Finally, and this is not the exhaustive list, of course, of all the requirements on conformity, but because there are quite many, there are also requirements regarding the updates of the content of the service, especially for security updates, terms for which such updates should be provided. Some rules regarding the omissions of the consumer to install on time such kind of security updates, which aim to limit the liability of the trader. Some rules regarding the responsibilities for integration or for improper integration of the content or the service within the user's environment. Sort of rules on the non-compatibility of the content of the service with the user environments, and so on and so on. To summarize all these requirements, I would say that updates are necessary to be provided for the entire duration of the contract, or for the entire duration that is expected and supposed the respective service or content to be available for the consumer and to be used. Of course there is limitation of the time when of the period of time during which the trader is responsible for maintaining the service or the content in conformity in cases where the consumer did not install on time the provided updates. As you know, sometimes some users, some consumers do not want to install updates. They are afraid of these updates. They don't know what to do with them. But at the end, of course, there are some limits after which the trader is not responsible for the functioning of such kind of content or service that have not been updated in a timely manner by the consumer. For the integration, the rules are different depending on who is integrating the content of the service, and of course, if this what is important to know is that if the content of the service are integrated in the user environment by the very user, again, in case of improper integration, it is possible the trader to be held liable if, for example, the consumer was not provided by the trader with proper instructions, adequate instructions on this integration, and so on. What is important to be said also is that the burden of proof is on trader, whether the trader has complied with all these requirements is his problem. Said straight to the point. So and this rule about the burden of proof is also spread to the sale of goods. So all these rules on conformity are pretty much similar for the sale of goods, of course, taking into account the fact that we're talking here for digital type of goods, but otherwise the logic is the same. After that, of course, the law provides for different remedies for the consumers. Consumers have the opportunity to submit claims and to request mostly and mainly from the trader to bring the digital content or service into conformity. Also, in case of non-conformity, the consumers have the right also to request a proportionate reduction of the price, where the rules are quite detailed and I would say ensure proper justice for both parties, because in cases where for a certain period of time the content or the service were in conformity, then this period of time should be taken into account, and the reduction of the price should be proportionate to the period of time only when the content of the service were not in conformity. Of course, in certain cases, the consumer also have the right to terminate the contract. It is important to know that all these requirements and all these options for the consumer are made in favor of the consumer, so they're quite large, and it's not really necessary the non-conformity to be that severe to provide the consumer with these remedies. Certain restrictions are also applicable for the trader with regard to the use of generated content after the termination of the contract. This is also kind of novelty, and I would like to mention this because it's interesting and important. So, as you may know, during the years, one of the main issue and topic that was discussed, for example, with regard to social media, is the fact that our content is after we stop the use of their services, it seems like being locked in the social media. We cannot remove this content from this social media and so on. And then we have the right to be forgotten and GDPR, and now we have another aspect, and I think it's pretty important. It's about the fact that once we stop using certain service, the content that we have created, like for example, that is not personal data, just personal data, but for example, photos, videos, audio files, and so on, and we have shared and used a specific platform to share this content or to store it. All such kind of content is restricted. The use of this content is restricted for the trader once the contract is terminated, and also the trader is obliged to ensure that there is a specific period of time during which the users, the consumers, can take down, can store and download their own user-generated content. Of course, there are some exceptions. For example, as I mentioned in the beginning of this presentation, in situation sometimes users' data are used for different statistical reports, some aggregated databases are created, and so on. So in such cases, when such kind of content are infused in and made in such aggregated form, of course, there is exception, and the trader can continue use the such content, but really we need to make again and to analyze and make sure that we fit within the exceptions. Otherwise, we will need to stop using the content. But it's also very important that we cannot just even if we terminate a contract with a user due to violations of our rules by this user, we cannot just block and arrest the user content in our platform and do not allow the user to take and use this content in other manners. So this is very, very important. Finally, not finally, but the final main aspect that is discussed with regard to digital content and digital services in the law concerns the modification of such digital content or digital service. What is specified and these rules are actually will be applicable only for contracts concluded after 1st of January 2002. Here I have a mistake in the date, but not 2001, but 2002. So what is meant by these modifications? The trader cannot modify the content of the service during the period of time when this content or service is supposed to be available and provided for the use of the consumer, unless it is such option is specified in the contract and there is a valid reason for such modification. And of course, the consumer needs to be notified prior to such modification. And such modifications should be performed at no additional cost for the consumer. And also, if such modification negatively impact the user, the consumer, then the consumer have the option to terminate the contract if he or she, if he wants. And sometimes the trader also may propose and ensure option for the consumer to use the content in the non-modified prior to the modification form. So what is meant by this? In general, in most cases, when the content or the service are modified, they are improved. And such kind of improvement normally is something good for the consumer. So such kind of modifications in more cases will not be restricted. But of course, the consumer needs to be properly informed about this, and there should be proper clauses in our general terms and conditions. The issue comes when we have a situation when we use the development of the service or the content to hide behind this restriction of the scope of the content of the service. This is something that may negatively impact the consumer, and when we are trying to introduce costs that are not reasonable to the consumer. So in such cases, we will need to comply with these rules, and such options are will become restricted after January for contracts concluded after 1st of January 2022. How to make sure that we are complying? What do we need to do? To summarize, first, we need to review our digital content and our digital services and make sure that they are compliant and that we are providing this content or services in a compliant manner with these rules. I would say in most cases this will be fact, and we may need just minor changes in our business model. But sometimes it may turn out that our business model may need more changes to make sure that we are compliant. And we for sure will need to update our terms and conditions in order to make sure that we have all the requirements introduce it properly in our contractual clauses. And we need to do this before January 2002, because we will need also to notify the consumers about these changes in the general terms and conditions. So I would say by the end of October, or at latest beginning of November, we will need to be completely ready with the changes in our terms and conditions, so that we are able to fit within the notification term provided by the consumer protection legislation in Bulgaria, and to notify on time the consumers about the changes in our general terms and conditions. And finally, a few words about the consumer claims and consumer guarantees with regard to sales of goods, sale of goods. As explained already, all these conformity rules are pretty much similar for the sale of goods. What is important to know is for what type of goods these rules will not apply. They will not apply for content on tangible medium. This will fall in the previous, mostly in the previous section. So for living animals, for sales of living animals, for second-hand goods sold at auctions, and for goods sold at by way of execution or otherwise by authority of law. So these are all these forceful public sales. For example, if we are have debts and or have performed some kind of violation of the law, and after that some of our property is sold without compulsory in a public sale by the competent authorities. Also, the rules will not apply to digital content. These rules about the sale of goods will not apply to digital content or digital services, because the rules of the previous section of the law will apply. But if the content of the service are incorporated in with the goods and are provided together with the goods under the sales contract. So if we buy a bundle together, the device, a good with some digital content and digital services, then the rules for sales of goods will apply also. To summarize also the liability of the trader in case of non-conformity of the sold goods, the commercial guarantee provided by law remain the same. It is 2 years. There are different moments from when this term starts, depending on whether we are talking about goods or services. For lack of conformity, which become apparent for the consumer within 1 year of the time when the goods were delivered, it will be presumed by law that such non-conformity existed at the time when the goods were delivered, unless otherwise proven, or unless this presumption is incompatible with the nature of the goods or with the nature of the lack of conformity. What this means is that in non-conformity becoming apparent for the consumer in the first year after the delivery, the consumer in most cases will not need to prove in any manner that actually this non-conformity is not result from his own use of the good. So this is very, very important. The remedies are the same as in that we know even now: reduction of the price, option to request reduction of the price, option to request bringing the good in conformity, option to terminate the contract. So all this, all option to request replacement of the goods. I hope that this information was useful for you, and I'm available for your questions so that I provide even more information on the topic.
Thank you. This is Lava. Do we have any requests? I want to remind you that if you want any clarification, you can write to the general address of the chamber, info@camcommit.bg, or you can contact the DPC studio. We are at your disposal for any kind of question or to receive some support. But I see some questions, so let me check.
Yeah.
Okay, we have some questions.
Yeah. I will read them, or you will read them.
Yeah.
Okay. So the first question is, what is intended with goods containing numeric, meaning digital elements according to the law? So this is, for example, this device is such kind of good, or smartwatch, or smart refrigerator. So this is these are goods that involve and part of their functioning is related to use of digital elements. Okay, is it possible to buy a laptop without the operating system, and how will be applied the new law? Well, yes, it's something that the law does not restrict such option. What is important is that when the user buy such kind of goods, such kind of products, to be informed from the very beginning whether and what part of these elements will be provided to the consumers, and will fall within the contract. So you can buy a laptop without operating system or not, but you need to be aware of this from the very beginning. Also, I think I lost the chat, but yeah, I find it. And finally, do you think that this law will be beneficial and easier than before for the traders? No, definitely no. As I said in the beginning, the legal technique is pretty poor, because we have now not one law but two laws that are actually arranging consumer rights. We have consumer protection law for consumer protection, and we have this new law, and some of the rules from the consumer protection law were transferred to the new law, and also in the new law it's very casuistic, so meaning that the rules are very detailed and specific, and they're repeated almost twice, because once they are specified for the digital content and digital services, and after that they're again specified for goods in general, but the rules are quite similar, and there is no any effort from the legislator to somehow during the transposition of the rules make them more simple, more clear, more focused, or to structure them in better manner. This was not done, and we will need to check all the time where that we comply with the two laws. So it will not become easier, but it does not introduce really very severe new rules or obligations for the trader. The logic continues to be the same as before this new law. So from this point of view, it will be not that difficult, except those aspects that I mentioned for free of charge services that are using the personal data of their consumers for some additional business purposes, or for this aspect regarding the advertisement of the goods, or for the advertisement of digital content or services. And I think that these are the questions that I see at this stage in the
Yeah.
I just want to ask something to this is Laura, if I can.
Yeah.
So this is Laura. First of all, you underline the strict connection and a strict relationship between the trader and the consumer. So I think that this is something that we have to put in evidence as well. In this phase, related to this, I just want to ask you that there's exception in some sectors. You mentioned healthcare and financial services. What about the education system and the relationship with the public institutions taking care about education?
Yeah, the public services are excluded. The administrative services are excluded. But some, so all the relations with, for example, the revenue agency, social security institute, and so on, they're excluded. These are not consumers, consumer type of relations. But for the educational system, I would say this will be, it's not excluded, and I would say what the school is doing within their main functions. I think this will not fall. This is not again a consumer type of relationship, but for example, we have so many new additional services or aspects that are provided by the educational institutions or by private schools or some other participants in the educational system that are not really within the state's structure. All these activities need to be analyzed and checked whether they fall within the scope of the law. First will be whether they're paid by the consumers in certain manner, and second is whether even if they're free of charge, they are using somehow personal data of the consumers for other purposes that are outside of the strict necessity to provide the service and to comply with law. So yeah, this is something that fall partially within the same is with the healthcare, of course.
Yeah, exactly, because it's a specific topic, and let's say the digitalization of services is also impacting on the public and the private, let's say, educational system.
But the rules, if I can add something, the rules and the definitions of digital content and digital service are very broad, technically neutral, and I would say that they're so flexible that we can expect that many activities will fit within these definitions, and the authorities will interpret these definitions in a manner so that encompass the future development of digitalization in our day-to-day life.
Okay, clear. Thanks a lot, Desislava.
Okay.
Thank you for your participation, and do scoro.
Thank you very much.
Bye, do scoro.
Thanks a lot to all. Thank you so much, Vesel again, and Desislava as well. Nicoletta, I just want to add something more in order to close the webinar. We, even if mainly basically the time is hard and everybody is working, we have a great followers on during the live streaming, reaching 100 people, and we let's say shared as well on our LinkedIn. So basically I think we extended the audience, and we will follow up together the webinar with DCP, with our partner DCP. Thanks a lot also my colleague Nicoletta Bisero, who was the main organizer of this together with Vesela, and I wish you a pleasant journey and pleasant working days. Thanks a lot, and grazie a tutti per la partecipazione.
Thank you.
Rosa.
Thank you.
Bye.
Bye to all.